The unofficial Bridgerton musical is the first musical album to be created exclusively via TikTok. What started as a piece of fan art amongst the sea of other TikTok content created in the wake of the explosive release of Bridgerton grew into a massive cult following, a Grammy Award-winning album, and now a major new lawsuit filed by Netflix against these two 20-year-old show tunes nerds. Let's break down what the heck is going on and if this case has larger implications for creating fan art going forward. First, some background info. Abigail Barlow's background info is kind of lacking on the internet, but she's a young singer who gives a strong, musical theater nerd energy and started a TikTok account to post her original compositions. Emily Baer's background info is more readily available because she was one of these child prodigies who was 6 years old playing Mozart on the Ellen DeGeneres show. By the way, she was born in 2001. I think this might have been the first time I was reading the Wikipedia article for someone born in this century. And yeah, I was shook. Yes, sometimes I do use Wikipedia as a source. Grow up. It's just for basic personal background info like this and not for my legal analysis, okay? So calm down. Anyway, Emily Baer is 20 and a child prodigy pianist. Quincy Jones has been her mentor since she was 6 years old. She started composing songs at 2 years old. This girl's unreal. She also played piano for the soundtrack of the game Siberia: The World Before, which I play sometimes over on my Twitch channel. Shameless plug. But also those games are some of my favorites, so it's pretty cool. So Bridgerton was originally a book series written by Julia Quinn. Then super producer Shonda Rhimes adapted the story for Netflix, and like pretty much anything that Shondaland touches, it turned to gold. So Bridgerton, the show, comes out Christmas Day 2020. We're all locked inside. It's spicy as hell. It was the perfect female gaze show. Left people quaking in their boots. It was an immediate sensation. Days after it premiered, Barlow posted a TikTok being like, okay, but what if Bridgerton were a musical though? And then sang part of a song that she wrote where she took a line of dialogue and made a song around it. It exploded. And then she partnered with Emily Baer. I'm unclear how they know each other. And Emily would play piano and produce the music and do backing vocals. And then they started putting out tons of TikToks of their music that they wrote using popular lines and quotes from the show and writing songs for each individual character. And in literally a few months, the pair were being interviewed all over the place. They recorded their songs, and by September 2021, just 9 months later, they released an album. And a few months after that, they were named in the Forbes 30 Under 30 and won a Grammy. A Grammy. They were the youngest winners ever in the musical theater category and the only women nominated that year. Okay, so this all happened in the last year and a half. And you may be wondering, where does copyright, or at the very least plagiarism, come into this? Well, I'm so glad you asked. Let's talk about copyright law. First, though, let me thank my partner on today's video, 𝗓𝗏. 𝗓𝗏 is a subscription service that ships high-quality personalized vitamins, supplements, and powders conveniently to your door every month. Their vitamins come in convenient individual packets, so traveling is super easy. I have a long weekend away for a wedding at the end of this month, and these little packets are gonna make it so easy. You take a short quiz about your lifestyle and health goals, and then 𝗓𝗏 gives you a personal recommendation for your supplements. Also, these little packs, they're made of plant-based compostable film, which I love, and they're really cute. I also received a couple little extras from 𝗓𝗏 that I've been loving. I've recently been trying to get back into weightlifting, humble brag, and 𝗓𝗏 vanilla protein. It's great for a little post-workout boost. Also, they have these focus vitamins filled with vitamin B and other helpful supplements to help me focus, which I've genuinely found helpful on days when I need a lot of energy to get things done. Special for my viewers, you can go to takecareof.com and enter code Leeja50 to get 50% off your first 𝗓𝗏 order. Visit the link in the description below. Thanks, 𝗓𝗏. Okay, so if you're new around here, I'm a lawyer and I recently switched specialties to family law, but before that I focused on intellectual property, and it still holds a special place in my heart. It just turns out that practicing IP law meant a lot of squabbling over big corporations using words that are trademarked, and that's frankly no way to spend a life. But I am a creative person and a creator, so I like the more conceptual, intellectual aspects of IP law. And I'm always happy to get to make a video about IP law. So, copyrights. They protect an original work of art. Specifically, they protect the rights of the artist or author from having their work used without their permission. Copyrights give a bundle of rights to authors, including the right to reproduce, perform, show, or create derivative works of the original work. A derivative work is a new creation that's made based off another copyrighted work and contains major copyrightable elements of the original work. So like if we're talking about stories or plays, characters with the same names or characteristics, the same verbatim lines, similar plot lines, the same characters put into new plot lines, etc. So the copyright owner of the original work gets the right to say whether or not someone can make a derivative work from the original. So if you don't have permission to write that fan fiction, it could technically be copyright infringement. However, there's also this thing called fair use, which allows for certain exceptions to complete copyright protections. Because while we want to protect artists' rights, we also don't want to completely curb people's free speech rights. So while you can't use someone's copyrighted material generally, you can if your use falls into an exception, including criticism and parody, commentary, news reporting, teaching, or research, etc. But it's not a blanket exception. So there's never gonna be a time when you're 100% in the clear, because there's a lot of gray area. And the only way to know for sure whether your use actually counts as a fair use exception is to get a judge to say that it does, which would require a lawsuit. When judges are trying to figure out whether your use counts as fair use, they use a 4-factor test. First, they look at the purpose and character of the use, specifically how the derivative work incorporates the original work, and then how the derivative work is then used. If the new work is really transformative, then it's more likely to be fair use. But if you're deriving commercial profit from the use, that makes it less likely to be fair use. Then they look at the nature of the original work. If it's fictional, then that makes your derivative work less likely to be fair use because it was entirely the creation of the original author, as opposed to copyrighted material that's more fact and information based. Next, they look to the amount of the original work that was used in the derivative work. Does the derivative work use a substantial portion or more than is necessary of the original work? Is it lifting entire characters and verbatim lines? Is that more than is necessary? A judge has to figure that out. And then finally, they look at the effect of the derivative work on the potential market for the original work. So if the new work competes with the economic market for the original work, then that weighs against fair use. Okay, so any judge is going to look at this situation individually and weigh each of these factors. So looking at the Bridgerton musical songs and album, that is pretty clearly a derivative work, or a series, really, of derivative works. They take actual characters and write songs based on these characters created by someone else.
Never is thin, never is perfect, never for him, never deserving of the boy I love.
They take verbatim lines from the show and make songs out of them.
What a terrible soiree. What terrible people pretending they're happy in this masquerade.
They tell the story of the first season of Bridgerton, an original copyrighted work, through song. However, allegedly, Netflix and the cast and writers of Bridgerton were originally enthusiastic and supportive about the music that Barlow and Bear were writing. This is because, in the beginning, this work was more seen as fan art. Fan art is a specific kind of derivative work that fans make depicting characters or storylines, or fan fiction which takes recognizable characters and puts them in different settings or timelines. Those still very much are unlicensed derivative works and still technically copyright infringement. However, with any law, especially IP laws, you have to think practically about what's in the business's or copyright holder's best interests. It's a really bad look for a business to sue independent artists who are making art because they love a show or a book. Like, that's tacky, okay? And it would have been tacky for Netflix to have been like, hey, you 20-year-old girls in your bedroom writing music about our show, you cut that out. Okay, but then they wrote an album, and then they won a Grammy, and then the final straw came when they put on a for-profit concert of the songs where they also acted out scenes from the show and sold their own Bridgerton theme merch. They sold out the Kennedy Center in Washington, D.C., allegedly selling tickets for as much as $149 a pop, and they had another show scheduled in London when Netflix finally was like, wait just a damn minute. So Netflix filed a lawsuit against Barlow and Bear on July 29th, 2022, so just last month. In it, there are some interesting revelations. For example, the posters for the Barlow and Bear event state that the Bridgerton trademark, and yes, Netflix owns both the copyrights to Bridgerton, but also the trademark rights to the word Bridgerton, in addition to the copyrights in the show itself. The posters for the Barlow and Bear show said that the trademark was used with permission from Netflix, which Netflix denies. Additionally, Netflix claims that they were in contact with Barlow and Bear and explicitly said their songs were not authorized, and Barlow and Bear promised to consult with Netflix before taking steps beyond streaming their album online in audio-only format. Basically, there was an alleged understanding that they could make this album, but they couldn't derive significant profits from it. Because let's be honest, musicians aren't making money through streaming or album sales. They're making money through touring and performances. So that's where Netflix drew the line, allegedly. Additionally, and importantly, the lawsuit states that Netflix was putting on its own live events called the Queen's Ball, a Bridgerton experience, in 6 different cities, including DC. Netflix also offered Bridgerton-themed merch, and the Bridgerton soundtrack is available on streaming platforms. So they're clearly making an argument for that fourth prong that we talked about, the effect of the derivative work on the potential market for the original work. Netflix is saying they were making similar derivative works in the form of a live in-person experience, merch, and soundtrack sales. And that's a market that Barlow and Bear were allegedly infringing upon because they made their own versions without permission. So according to the lawsuit, despite the fact that Netflix drew this clear line in the sand that no live performances of music would happen, and despite assurances from Barlow and Bear people that no live performances would occur, Barlow and Bear went and they did it anyway. And Netflix even allegedly offered them a license to use their derivative works, perform them, move forward with their performance schedule, live shows, etc. We don't know the exact details of what that license agreement contained, but Barlow and Bear allegedly refused. We don't know why, but it's possible that they didn't want to part with the profits, because usually a license like that requires that they turn over a percentage of the profits to Netflix or the original copyright holder, which makes sense. Like, if you're going to derive profit from my original work, I deserve a percentage of what you make. It's a common practice, both with copyrighted works and also with trademarks. Trademark owners will give a license to use the mark, which they did not do here, according to the lawsuit, despite the fact that the Bridgerton mark was plastered all over the merch and backdrops and booklets and everywhere for this Kennedy Center show, and even said that it was being used with Netflix's permission. So if what Netflix alleges in this lawsuit is true, it was pretty blatant and flagrant infringement of both copyrights and trademark rights. Like, you really can't do that. You can't use a trademark and make people think that you're affiliated with the source of the mark unless you have permission from the mark owner. It creates consumer confusion, which is like the #1 thing that trademarks are concerned with. And it appears that there were plans in the work for Barlow and Bear to perform more shows globally. Like, they are full steam ahead, guns a-blazing, trying to profit off this intellectual property that they did not originate. Like, they made the songs, but the underlying everything is based off of something they didn't come up with. And if the lawsuit is true, it's honestly pretty tacky of Barlow and Bear, frankly. Okay, so the lawsuit's official allegations against Barlow and Bear are for copyright infringement, declaratory relief in the form of the judge declaring that they have no right or license to use Bridgerton in any way, trademark infringement for using the word Bridgerton, false designation of origin, which is another trademark-related claim for falsely making it seem like they were affiliated with Netflix and Bridgerton when they weren't. And Netflix is seeking damages as allowed under the statute, which allows for either actual damages, so the amount that Netflix missed out on because of their use, plus the profits that Barlow and Bear made, or a set amount, which, if the infringement can be shown to be willful, meaning done knowingly with disregard for Netflix's rights, then they can get up to $150,000 for the copyright claim alone. So this lawsuit was just brought by Netflix, not by Shonda Rhimes or Julia Quinn, the author of the original books. This is probably partially because Netflix just has the resources as a huge company to bring this kind of lawsuit, and because they were the ones in negotiations with Barlow and Bear. They're also the ones creating the live in-person Bridgerton experiences, the soundtracks, and the merch, so they likely had a better argument that Barlow and Bear's activities infringed on their market for derivative works. However, both Shonda Rhimes and Julia Quinn released statements in support of Netflix's lawsuit. Rhimes said, "There's so much joy in seeing audiences fall in love with Bridgerton and watching the creative ways they express their fandom. What started as a fun celebration by Barlow and Bear on social media has turned into the blatant taking of intellectual property solely for Barlow and Bear's financial benefit." And Julia Quinn said, "I would hope that Barlow and Bear, who share my position as independent creative professionals, understand the need to protect other professionals' intellectual property, including the characters and stories I created in the Bridgerton novels over 20 years ago." And even though Barlow and Bear still have huge online followings, Barlow has like 2.4 million TikTok followers, and the album was wildly successful and popular, this lawsuit has Barlow and Bear audiences turning against them. Not so much because people are supportive of Netflix, but more so because of the infringement against Shonda Rhimes and Julia Quinn and the blatantness of it, with some commenters saying that they just girl boss too close to the sun. And I mean, these gals are literally literally 20 years old. That's so much fame and pressure so quickly, and they had professionals around them, apparently, including lawyers, allegedly, who hopefully were advising them about the legal implications of their actions. It could be that they got cocky, or they and their people decided that it was a calculated business risk to just move forward with the musical anyway. We have no way of knowing what they were thinking yet. No official statement has been released. Barlow and Bear's social media have been silent, and the parties just agreed to a stipulation to extend the deadline for Barlow and Bear to answer the complaint to September 22nd. Maybe they're actually listening to their legal help at this point and waiting for the official response to be filed before making any social media posts about it. A lot of legal experts are saying that this will probably settle out of court, which seems most likely. This means that it wouldn't set any official court precedent. But people are afraid that this lawsuit could have a chilling effect on fan art moving forward. Frankly, I think that's an overblown fear. Maybe if this makes it to trial and the judge makes a ruling that has implications for like basic fan art, then maybe. But cases go to trial like 1% of the time, so it's really unlikely here. And this was clearly far and away a specific and special case of fan art that blatantly copied the original work in very explicit ways and then started deriving significant profit for it. Average fan art is like fan fiction written anonymously in a forum, or a painting that you post on social media, maybe art that you sell on Etsy or something, which may result in you receiving a cease and desist letter, but like I said, it's generally pretty tacky for a company to take legal action against small potatoes. You know, it's very rare that fan art rises to the level of fame and popularity of Barlow and Bear's work. The only thing I can even think of that comes close is 50 Shades of Grey, which was based on fan fiction that was inspired by Twilight, which I watched for the first time and live tweeted over on my Twitter if you want to see my reaction to the Twilight movies. Anyway, the fan fiction itself was originally called Master of the Universe, and more obviously put Twilight characters into highly sexual situations. This was more clearly a derivative work of the Twilight franchise and could have subjected the author, E.L. James, to copyright issues. But again, she was an anonymous poster in a fan fiction forum. When the original fan fiction became really popular, she reworked it into 50 Shades of Grey and its sequels, removing any reference to the original Twilight characters. And now the books truly in no way resemble the Twilight franchise. Being inspired by Twilight is not the same thing as being a derivative work based on Twilight. So in that way, E.L. James covered her ass and avoided litigation over copyright infringement. The same clearly cannot be said of this situation. Barlow and Bear took characters and did not change anything, and took verbatim quotes from the show and expanded upon them, and followed the setting and overall plot points in their music to a T. Because it's such a specific situation, I really don't think that it's gonna have the devastating consequences for fan art that some people are worried about. But what do you think? Are you team Netflix, Shonda Rhimes, Julia Quinn, or are you team Barlow and Bear? They clearly still have a huge following, so I may have made some enemies from saying that I think it was tacky of them based on this alleged information. But I'm fascinated to see what their answer says, if they even get that far. Like I said, they could settle out of court, which isn't public, so who knows what could happen. If you enjoyed this and want to support my work bringing you videos like this, please consider becoming a member of this channel or joining me over on Patreon, where you have a lively Discord chat, Leeja's book club, behind the scenes stuff, and so much more. Thank you especially to my newest Patreon supporter, Dixie, and as always, thank you to my royal patrons, Old Man Pence, Fork McSpoon, Ellen L, and Daniel Taylor, and a very special thank you to my multi-platinum patrons, Brett Piantek and Cyrus Solka. Your generosity is greatly appreciated, and it makes this channel what it is, so thank you. Thank you again to my partner on today's video, Care Of. Go to the link in the description below and use code Leeja50 for 50% off your first order. Thanks, Care Of. If you like this video, you might also like my video where I react to petty celebrity wills. Thanks so much for watching. Have a good day. Bye-bye.